we have to focus on the federal rules of evidence. These are rules 701 through 706. So we're going to talk about 4 of them. I want to say up front, please forgive me. This is kind of dry material in here, but you really need to walk through these elements in this set so that you understand if you're going to become a forensics expert and you're going to testify in the court, how you're going to achieve those goals. These are a very strict set of guidelines. If we as forensics experts are trying to be scientific about our data acquisition and our forensics investigation, the court is trying to be scientific about how they allow people to testify and what evidence they will accept. So they're just doing it from their side, and so this is where we intersect with the court. So these are a lot of quotes, and please forgive me, but here, take a look and read this. If the scientific, technical, or other specialized knowledge will assist the triers of fact to understand the evidence or to determine a fact in issue, a witness qualified as an expert by knowledge, skill, experience, training, or education may testify thereto in the form of an opinion or otherwise. That last piece there, opinion. They're trying to say these facts are beyond us, and your opinion helps to get us there. So now, how can you testify? Well, there's 3 steps here. The expert may testify only if the testimony is based upon sufficient facts or data. You have to support what you think by the facts. Is the product of reliable principles and methods. You've got to know your principles, you've got to know your methods. When you go to study for your test, I want you to get a better score than me. I want you to get the best score you possibly can. And I really would like to hear from you. Please send me an email about your test results, about what you've done. Talk to me, because we all need smart people and forensics investigators around us. I'll buy you a cup of coffee in your town if you can get a better score in the test than me. So that's my deal to you. But you got to send me a copy of your score report. The witness has applied the principles and methods reliably to the facts of this case. When it says the case, that means this case. In other words, what's your methodology, and did you apply it here? You've got to be very clear about this. In Rule 701, we're saying we think that we need an expert, and here's the conditions under which we will expect that expert to perform. 702 provides that expert witness may only testify if the testimony is based on that sufficient data. This is that same piece down below. Testimony is product of reliable principles and methods. Principles and methods from where? I don't think that you get one certification and you become automatically an expert. I don't think that you use one tool, EnCase or FTK or SMART or Helix, and you become an expert. I think that you become an expert when you learn about all of these. At the very beginning of the course, I talked about where I got my information. I didn't just read the official curriculum from EC Council. I read all the material that SANS had to offer, and then inside of SANS there were a whole bunch of links to a bunch of information, and I read that information so that I could become an expert at teaching this particular material by digging deeper than just what one person or one organization had to say. Knowing more than just the principles and methods of the EC Council, knowing more than that is what makes you tend toward an expert. 703. The facts or data in the particular case upon which an expert bases an opinion or inference may be those perceived by or made known to an expert at or before the hearing. Somebody gave you paper for you to review. Next part. If of a type of reasonability relied upon by the experts in a particular field in the forming opinions or inference upon the subject, the facts or data need not be admissible in evidence in order for the opinion or inference to be admitted. You don't have to say, here's all the data and this is my opinion. You can say, here is my opinion. Now, the next question by the opposing counsel is, what do you base that upon? blah, 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 blah. And then what they're going to do is they're going to say, since you base it upon this, in an earlier article, you wrote this thing right here, and it's counter to that. They'll take things out of context and try and crush what you're doing at this moment in time. You have to be prepared to know all of the writings that you've done. That's part of your preparation. And 703 says you can state it, but then you got to back it up later on is really what it boils down to. Facts or data that are otherwise inadmissible shall not be disclosed to the jury by the proponent of the opinion or inference unless the court determines that their probative value in assisting the jury to evaluate the expert's opinion substantially outweighs their prejudicial effect. The judge gets to decide a lot of this information. And you really have to work hand in hand with the court because, well, first off, what's going to happen before that is you're working with the attorney on your side, and they're going to say, you know what, that would be inadmissible, and what do you think we're going to get out of that if we do try to put that in? And I go, well, this piece right here clearly indicates this path, this line and logic of reason, this process of them continuing to do something. They keep on going to the web and doing this update over and over and over and over again. And really what they're doing there is they're not trying to do an update. They're trying to delay some licensing agreement, or they're trying to delay something. They're working around the licensing agreement that's in place, and therefore they're stealing from those people. It's not the actual fact of what they're doing, the updating, that supports this. That piece of inadmissible evidence, this has nothing to do with what we're trying to try at hand. No, it actually does, and here's why. Again, for 703, really let the attorney guide what's going on here. Let's switch gears here and talk about preparing for the deposition. 4 people minimum will be in the deposition. You, a court reporter, both sides of the counsel. So prosecution and defense. That's the minimum that's going to be there. You must know that minimum. You, court reporter, both sides. In the deposition, your attorney for your side is going to lay out the case, and this is the opportunity for them to know how you're going to act in a court of law. So this is kind of the interview after the interview, and they're going to say, let me ask you any of these questions that I want to. Since they're not going to be in court in front of the judge or the jury at this moment in time, they'll ask you everything. The opposing counsel, when they get in the room, by the way, what they're going to do is they're going to have a little chit-chat for, oh, this is a no big proceeding. This isn't a big deal. Let's just go ahead. Hey, listen, do you play golf? Chit-chat, and let's go ahead and, oh, we're buddies here. Don't do that. Don't play that game. You come in, you're all business. You come in, you're ready to present. You look the part. You stick to what's going on in this particular instance. You answer your attorney's questions. The opposing counsel is also going to pick at you, and they're going to see, hey, can I rip this person apart? What are their weaknesses? How do I get at them in that deposition? They're going to assess you and say, are you going to be effective as a witness for your side? Or are they going to be able to beat you apart when they get you on the stand? And they'll test you and probe you and see what's going on. If the person that's hiring you over here thinks that you're good, and then all of a sudden you're ripped to shreds by the opposing counsel, you're not going to court. They're going to boot you right out of there, and they're going to put somebody else in there. And now the thing that you've done is you've kind of sunk this person's case a little bit because you've given away information that shouldn't be there that may help the opposing counsel. But if you're staying scientific, if you're saying this is where this comes from, this is how I get this, and you're just stating those facts and focusing in on that, and then using your opinion to support to wrap all this stuff together in a nice, neat bow, then you'll be fine. This is the process of forensics. It describes the exhibits, it provides the statements of compensation, and it provides interpretation. Now let's look at that third point there. The other things we've talked about a lot. Provides a statement of compensation. You have to tell the court that you're getting paid. You have to tell the jury that you're getting paid to do this. And you have to state that up front. And you have to be very careful about that. So you're going to have to dig a little bit deeper to say, I'm worth this money. And you have to be willing to assert that. Now, there are two forms of questions that you're going to encounter. Leading and non-leading. Non-leading is direct. In a leading question, they try to limit you to a yes or no answer. A leading question would be something like, isn't it a fact that on this day you were drunk and didn't do the right thing and you screwed up the forensics test? What you want to say is, no. What you want to say is, well, I need to explain that. What's going to happen if you do that is that counsel is going to say, and this is the person that's against you, they're going to say, he's not being responsive. He's not saying yes or no. I ask him a yes or no question, and he's not being responsive. And you can say, I can't be truthful, and you have to make sure that this is true. I can't be truthful by answering yes or no at this point. You can't do that over and over and over again. You've got to let them do their yes and no so that they can build their case on their side. And you need to say yes or no. Now, what will happen is they'll say, isn't it true, taking something out of context to kind of lead you down their path. You have to be prepared for their line of logic. Now, your counsel has to do direct questions. The opposing counsel is the only one that's allowed to do leading questions. So remember, these questions are going to be coming at you pretty brutal, and you've got to be ready for it on both sides. Now, if in the original testimony that you're giving, they do these leading questions with you, and you can't clarify, then your counsel will then have another chance to come around and say, before he was saying this, can you please explain why you didn't feel comfortable answering that question that way? They'll pull it out of you later on if they want it. Remember, the two counsels are playing their chess game, and they know what evidence they want in, what evidence they don't want in. You can state your facts and then state your opinion on top of that. They can come back at you, do the leading questions, and then the next thing that happens is your counsel gets a chance to clean up this thing. Can you further explain that? When we talk about introducing evidence, this person over here, the opposing counsel, when they open the door to something, then this counsel can then say, well, it's been introduced into evidence properly. Now I can ask more questions about it. So they don't want to open up too many doors here. They want to keep it pretty narrow and lead you down their path. But when they start messing up, the opposing counsel, your side of the equation, they can help you by bringing this back up if they want to. Don't be frustrated by that. Let them go ahead and do it. Last thing that I have to offer you in this course is that most of the reading here in Expert Witness, I did not like what the EC Counsel had to say. I thought it was confusing, but I ran across Bruce Olson's information. And it's a brilliant 4-part How to Be an Effective Witness in Court. It's a brilliant article. I just gave you some feeling of that. It's an excellent article that really explains what you need to be, how you need to be as an expert witness. I want to wish you good luck on your exam. I want you to come talk to me, and if you have any problems whatsoever, please don't hesitate to ask us. And go get your Certified Hacking Forensics Investigator certifications.